the Elder Voice Family Advocate webinar titled Know Your Rights. I'm Chris Sundberg, Executive Director and founding member of Elder Voice. We work to end neglect, abuse, and exploitation of residents in long-term care settings. And we do this by advocating public policy changes that better protect and provide quality care for elders and vulnerable adults. And we educate residents, families, and public policy makers and the general public about the state of elder care. Let me take care of just a couple housekeeping issues. This is being both voice and video recorded and posted on our website, eldervoicefamilyadvocates.org. We're planning this to be about a 1 hour presentation, but we can extend a bit if there's enough interest and questions. We ask that you use the chat feature, which you find at the bottom of your screen, to ask your questions. And then at the end of Suzy's presentation, I will ask Suzy to address them one by one. Knowing your legal rights is always important, but in the world of COVID-19, it's imperative. This pandemic is seriously impacting everyone living in long-term care. And we are daily getting reports of severe neglect and abuse of residents and disregard for the families. This is why Elder Voice is aggressively pursuing additional protections during this pandemic, which will include better infection control standards, staffing requirements, termination protections, and much more. You'll hear a lot more from us about this subject, and we will be having a webinar in early September with Senator Scott Dibble and Representative Ginny Cleaborn, who are authoring our legislative bill, and they will be discussing exactly why this important legislation is needed and needed now. With that, it's a pleasure to introduce our speaker tonight. Suzy Scheller, or Suzy as she prefers to be called, is a solo practitioner with Scheller Legal Solutions, LLC. She practices in the areas of elder abuse and neglect litigation, financial exploitation, elder law, elder mediation as a qualified neutral, and estate planning. And I'm proud to say Suzy is a founder of Elder Voice Family Advocates, and she is currently our legal advisor as well. Suzy's instrumental in planning and drafting legislation for Elder Voice and working with our other coalition of advocate partners. Her expertise in elder law is invaluable. Additionally, Suzy is active in the elder law community, including promoting the interests of the elderly and disabled through legal representation and supporting families as they care for aging parents through consultation and mediation. She's also a founding board member of Minnesota Elder Justice Center and is the former chair and current governing council member of the Elder Law section of the Minnesota State Bar Association. Awards include the 2018 Mary Alice Goodall Award from the Elder Law section for outstanding contributions to the practice of elder law. She's a graduate of Hamline University of Law and an adjunct professor in elder law at the Mitchell Hamline School of Law. She's a frequent author and speaker on elder abuse and elder law issues. And I can speak personally about her passion for bringing the interests of the residents and their families to a broader stakeholder community in an effort to prevent the harm and improve the quality of life for vulnerable adults and their families. With this, it's a pleasure to turn this over to Suzy, and it's all yours. Thank you.
All right. Thank you, Chris, for that wonderful introduction. Elder Voice Family Advocates is near and dear to my heart. Listening to stories over the year, it became apparent that that was a voice that was needed in the conversation. And so I'm very glad to have courageous people such as those on this call, as well as Elder Voice Family Advocates, talking about the resident experience and the family experience in our long-term care facilities. So today, it's about know your legal rights. That was a lengthy introduction, a wonderful introduction, so we'll move forward from there. What I'm going to talk about today is starting with some presumptions in the law about rights, because we hear the word legal rights, but sometimes it's a little difficult to get our minds around what that means and where do we find the legal rights. I have calls frequently from clients or potential clients asking, do they have a right to do this, or do they have a right to do that? And it's pulled together. All these rights are pulled together from multiple sources. So we're going to start with some presumptions, some history, overview of key laws, summary of the rights in the long-term care settings, notably the nursing home setting, skilled nursing facility and nursing facility. And then in the assisted living setting, which, as you know, in Minnesota is unique. It's a home care setting in an assisted living building. So in a housing with services registered establishment. We'll talk about enforcement of these rights, because that's the sort of the million-dollar question, right? The key question is, if we have rights, how do we enforce them? And then the impacts of COVID-19 and the practical tips during COVID-19 as providers, residents, families alike are trying to balance the rights that they have with the realities of COVID. It is a lot of information. I will be providing this PowerPoint after this presentation for you to dig more carefully into the language of the law if you wish to do that. So there will be some points at which I skim over some of the written material with the intent that you can come back to it and look at that law language at a later point in time. So let's start with presumptions in the law. We need to understand that persons 18 plus, 18 or over, are competent to manage their lives. That's where we start. In our legal system, we say you are a minor if you are under the age of 18. There might be some emancipated minors for certain situations. But once you hit 18, the law presumes that you have competency to manage your life. In Minnesota, notably, there is no category of vulnerability based solely on age. In Wisconsin, for instance, there is an age category that if you are a certain age, 65, 80, 85, you are looked at differently under the law, and we seek to protect to a greater extent. But we have no age-based category of vulnerability, except, of course, a vulnerable adult statute does say that if you're over the age of 18 plus, then you may be considered a vulnerable adult, but it's not just because of your age. You have to meet certain other criteria. So I wanted to note that people can manage their lives, and most people do, right? Presumption 2, persons age 18 plus can make decisions that are not perceived to be in their best interest, not perceived by others to be in their best interest. We have sort of a sliding scale analysis in the law that the greater the impact of the person's actions on others around them, the more we have concern. Or the greater their incapacity, the more we have concern, such as a court-ordered guardianship, for instance. But generally speaking, we have the right to make decisions others would not think are in our best interest. And that's really, really hard point for many of us in the vulnerable adult community, because we don't want to see people get hurt. The presumption number 3 that is important in this discussion is the rights flow to the person who is receiving the services in long-term care. They do not flow to the family member. Of course, if a person has an agent, then those rights would flow to the agent, whether it's a court-appointed guardian or a healthcare agent appointed in a valid healthcare directive, the persons of those natures. But the rights that we're talking about are for the person receiving services. Just a general definition of a legal right is a claim recognized and delimited by law for the purpose of securing it. So we state it in law because we want to secure the right. We have a lot of rights in the law. It actually doesn't take a tremendous amount, and I say that tongue-in-cheek just a little bit, to get a right put into law. The real battleground is how you enforce those rights. But we want to recognize in law certain things that we state are important and necessary to a person receiving services, and we'll talk about those. I want to talk just a bit about the history of rights development. We really have the history grounded in our US Constitution in 1791, where we had the first 10 amendments as the Bill of Rights: freedom of expression, freedom of the press, freedom of assembly, religion. We had those fundamental rights that exist then in the 14th Amendment that came later. So we have the Bill of Rights, later we have the 14th Amendment in the US Constitution, which talks about right to marry and privacy and interstate travel. That's the Equal Protection Clause and in part the Due Process Clause of the United States Constitution. That came in 1868. Equal protection analysis, and we just had an example of this in an employment case based on gender, sexual orientation, and gender identity. But what we do is we ask whether or not this particular law is based in a class of persons that have been denied equal protection under the law. So this is an equal protection analysis, and there's a point to me mentioning this. It's important to decide who we're talking about. Is it a group of persons based on race? Is it based on disability? Is it based on gender? And if we determine that that is a suspect class, the higher the level of scrutiny, and that's why the Supreme Court then states the decisions that they make based on the level of scrutiny coming out of the class of persons. So for instance, if we have a suspect class, that equals strict scrutiny. The government law will be strictly scrutinized to see if it discriminates against those persons. Race, religion, national origin, and alienage are considered suspect classes. Quasi-suspect classes are those who receive intermediate scrutiny, not as high as strict, not as low as rational basis. Those groups are gender, legitimacy of birth, and arguably sexual orientation. Non-suspect classes is rational basis scrutiny, meaning the law only has to be reasonably related to a government purpose. Note that both age and disability are non-suspect classes. They receive the lowest level of scrutiny, which is why we don't have stronger laws in the United States related to discrimination based on age and disability. That's important to note. So if you look at this, strict scrutiny creates a fundamental right. It is rooted in tradition and implicit in our concept of ordered liberty. The action must be necessary to achieve a compelling government interest. The government often loses because they can't justify the action. When you flip it to the rational basis scrutiny, which is age and disability, there is no fundamental right associated with those claims, persons. Action that must be rationally related to a legitimate government purpose, and the government often wins. So again, the main point here is that age and disability are not considered suspect classes, which is why we don't have greater protections in some of our laws based on those two categories. Now in Minnesota, it mirrored the US Constitution development largely. In 1858, we had the Bill of Rights. We have our own Equal Protection Clause that's very similar to the US Constitution. We state that no member of the state shall be disenfranchised or deprived of the rights and privileges secured to the citizens. That will be analyzed under some of the same analysis we just talked about. Are they a suspect class? We also have a right to remedy for injury, which is notable for those in long-term care facilities who are injured. So these rights come from multiple sources. They may be enumerated specifically in a healthcare Bill of Rights. They may be referenced in another specific statute, like the right to place a camera in a room or the prohibition against retaliation. We would consider those some rights because we can grieve and complain about concerns at the facility without fear of retaliation. That's what the law tells us, but it's not specifically in the Bill of Rights. We have general protections under the law that may require some constitutional analysis, like I just described. And there are multiple state and federal law and regulations. So I want you to understand, we actually call this a bundle of rights or a bundle of sticks sometimes, all of these different sources for the rights. So the next few slides are one when you get the PowerPoint that you might want to just save and mark. They're referencing the key laws that we deal with in the long-term care community. Age discrimination in employment. We don't get into that very much, but the age of 40 is actually when age discrimination in employment enters the field with this particular law. The Older Americans Act is an important act. It gives us our community social services and our ombudsman and other key services. That one has struggled with funding as of late, although they've continued to operate. It's just been one that hasn't been consistently funded in the Elder Justice Act coming out of their different things. The Americans with Disabilities Act, the ADA, is important, particularly as we look at COVID. Are we asking for reasonable accommodations based on some of the disabilities that are displayed in the residence? So we always want to keep that one in mind. Health and supportive services. What you should understand is at the nursing home level, there is a great distinction in rights and law between nursing home and all others, meaning assisted living in this case. The Omnibus Budget and Reconciliation Act created requirements for long-term care facilities. This law regulations are where we find the majority of our patient rights in nursing home residents. These also come out of the requirements for skilled nursing facilities, which are connected to Medicare statutes, and nursing facilities connected to Medicaid sources of payment. So these two, second and third laws here are really mirrored. The distinction is the source of payment, Medicare versus Medicaid. Patient rights on the federal level. The Rehabilitation Act of 1973 includes some rights for disabled individuals. The Medicare and Medicaid statutes do create some of those rights. Where we get our key rights in nursing home regulation is under those OBRA regulations, 42 CFR 43. And by the way, the OBRA regulations were revised for the first time since approximately 1980. There was one phase in 2016, 2017, 2018. There may have been one in 2019, but the point is they have recently been revised, and they previously had not been revised for a long time. A lot of the language reflects person-centered care and updates in our electronic age, technology, and some different concepts of that nature. Housing, the Federal Fair Housing Act, payment structures there, I'll let you look at that. Now we're going to Minnesota law, the overview. Our nursing home statutes are listed here. We have some corresponding rules. Our veterans home statutes, boarding care homes, there's approximately 30 in the state of Minnesota that they're not required to take Medicare payment. They're typically smaller operations, and there's again, fewer of those in Minnesota. Our home care license law can be found under 144A. Housing with services is the name for our assisted living buildings and other buildings that might be group homes or any building considered to possibly have vulnerable adults living in that facility or in that establishment. So HWS is the typical term. Actually, among providers, they call it an HWS setting. We call it an assisted living setting typically. Now, that is just a title protection in Minnesota. Again, it is not a license for assisted living, which is what the entire 2019 legislation has been about. We have some other regulations related to memory care. If we want to look at patient rights specific to Minnesota, again, this is a summary of where you'll find them. Assisted living rights addendum that is effective now only for those who have title protection to call themselves an assisted living. It's very brief. Really, the biggest distinction is that it's a 30-day notice for a termination rather than a 10-day notice under the Home Care Bill of Rights. The Assisted Living Bill of Rights after we have licensure, which currently in law is set to start August 1st, 2021, is listed here. The Health Care Bill of Rights will govern nursing homes and boarding care homes. The Home Care Bill of Rights will be the main law governing assisted living and home care. Don't forget about the Hospice Bill of Rights. It is an important area of the law that we don't talk about often. We have the Minnesota Human Rights Act. Persons subject to guardianship or conservatorship as of August 1st, 2020, there's new laws related to guardian conservatorship where the language is updated from no longer calling the person a ward, but a person subject to guardianship or conservatorship, and they have rights listed here. The Vulnerable Adult Act will also give some what we would consider guidance on rights defining neglect, abuse, financial expectation, who is a vulnerable adult. Continuing the overview, we have employee regulations under the Nurse Practice Act. There are important advertising protections under the assisted living title protection, the attorney general responsibility to prevent consumer fraud. We often connect consumer fraud concepts with transparency of assisted living services. Disclosure of special status for memory care is also a separate piece under the law. and false statement in advertising. Again, we get concerned about if we're advertising memory care but not providing training and services. Housing, very important to remember landlord-tenant law, particularly because of our model in Minnesota that has a housing with services establishment. It is a landlord, and then the services are separately contracted for. All right, I've got a bit in here about Wisconsin for those who are interested. We have often a lot of people crossing over with their laws between Minnesota and Wisconsin. All right, so in summary, on the key areas of the Bill of Rights, the nursing home is regulated by those OBRA regulations, the Minnesota Statute Healthcare Bill of Rights, the nursing home law, and Minnesota rules governing nursing homes. Assisted living pre-licensure is largely governed by the Home Care Bill of Rights. Post-licensure, they have their own Bill of Rights, and home care laws. Both are governed by the Vulnerable Adult Act. I wanted to take a note about medical records because I often get this question. Again, it's not directly, do I have a right to this? Well, we know we have a right to our own medical records, and our agents have a right to our medical records, but how much should it cost? How long should it take? How is this interpreted? And I find this to be one of the most difficult areas to interpret. I see these provisions under HIPAA and the Minnesota Healthcare Records Act used as swords often instead of shields, which they're intended to protect the confidentiality of the information, but yet often it's difficult even for the patient to get their own records. So in general, we do have the Minnesota Healthcare Records Act, and then the HIPAA law is under 45 CFR 164. You have the right to your records. When does someone need to provide them once you request them? Well, under HIPAA, it's within 30 days. So that governs all settings, nursing home, assisted living. In the Minnesota Healthcare Records Act, it simply says promptly provide. By the way, there is a growing movement among providers primarily to have Minnesota Healthcare Records Act mirror HIPAA because the discrepancies cause some problems. Here's one of them in the timing. However, in the nursing home OBRA regulations, the resident has a right to their records within 2 days. So they need to give 2 days notice to get their records, and they are asked to have access to their records within 24 hours. So again, if you've got a crisis or emergency, it is important for you to know that you should be able to get those records within 2 days and 24 hours at least access to them. I actually have people often who in non-COVID times go into the records office at the facility and look at the records, look through them to try to find what they might be needing. In general, if the resident has requested that the records be delivered to the resident, again, we have a distinction in law with medical record requests that if I as a third party request them, they're treated differently than if you as the patient and resident first party request them. So important to note that records for the resident should be free at no cost under the Minnesota Healthcare Records Act when the patient requests the copy for the purposes of reviewing current medical care. So the resident asking the facility for their records for current medical care should not be charged. The electronic copies, this is an important HITECH Act rate. This was supposed to allow records to be much less expensive for residents who request records that are stored electronically, request electronically, and received electronically. So the HITECH rate would apply, such as just the cost of the USB drive to send them. And whenever I advise clients, I state you should ask for it under the HITECH Act because that is not the per page copy charge. It shouldn't be, but rather the electronic copy charge. Paper copies in Minnesota as of 2020, $19.19 retrieval fee plus per page cost of $1.44. And that's typically what you're going to see records defaulted to. You just want to know to ask again, current medical care, waive the costs that I have a right to that as a resident or patient. So in a nursing home, again, we have overlays of this law. We had HIPAA, we had the Minnesota Healthcare Records Act, but in the OBRA regulations, the nursing home resident requesting their records is only to be charged labor, supply, and postage. Supply meaning the USB drive, for instance. So we have another layer for nursing home resident aside from the HIPAA and Minnesota Healthcare Records Act. And again, if you have questions, you can put them in that chat session. General overview of a right, the hard-fought right beginning January 1st, 2020, of placing a camera in the room, private space of a resident of a nursing home, boarding care home, housing with services, and assisted living. The independent living is considered your own apartment. That is not included in this law because it's presumed you can do that in your own home and in your apartment. You should have consent of one of the parties, and presumably that's the resident. The Minnesota statute 144.651 does not create a right under the Healthcare Bill of Rights for electronic monitoring, but rather 144.6502 is what establishes the process and the fact that you can place the camera. It is added as a right under the Home Care Bill of Rights for assisted living placement under 144A.44A. And so I think, honestly, it was difficult to change the Healthcare Bill of Rights because that's a pretty broad statute, but the Home Care Bill of Rights was a little bit more malleable to add that specific language in there. Retaliation, again, nursing home or assisted living, this is an additional provision that went into effect 8/1/2019 that lists prohibitions on retaliating for certain circumstances if you bring a grievance or complaint. There's another section that talks about filing a MARC report, etc. So I'm listing the laws where that important retaliation provision is listed. When we get to enforcement of rights, you will see that by and large this lacks an enforcement mechanism, which is typically the battleground in this arena. I also want to make sure that you understand, because again, housing with services is a landlord-tenant concept under Minnesota Statute 504B, there's some additional rights that flow out of covenants between the landlord and the tenant. The premises and all common areas must be fit for the use intended by the parties. That's an important covenant by the landlord. The landlord has to maintain the premises in compliance with the applicable health and safety laws of the state. So they choose to be a landlord and offer assisted living services in the building. The 504B says they should be complying with the health and safety laws of the state. Deposits, this tends to be a frequent question that I get is, do they have a right to keep my deposit? This is under landlord-tenant law, so applying to assisted living. Pre-lease and security deposits are to be returned, disclosed and returned. Another right within the landlord-tenant arena is that tenant can seek emergency services. There is I get questions also about the death of the resident in the assisted living. When do I have to get my loved one's things out? The landlord may take control of personal property 28 days after abandonment, and there's typically a 2-month notice on the death that the landlord could continue to seek payment in the less than 2-month notice. So those are within the law. All right, we're moving to key patient rights in a nursing facility. In general, we've enumerated where some of those rights come from in the nursing home context. I'm going to give you an example of a few of them. This is by no means exhaustive, but these are ones that I tend to be asked about. The right to access to the medical records, the right to refuse treatment. This is all in the nursing home context. The right to choose your own attending physician. You don't have to use the facility's physician. You can choose your own, but you may need to transport them there. The right to privacy and confidentiality of records. To examine survey results. You have a right to ask for and make sure you know how to request those results. The right to visit family and others. This is an important one during COVID, right? With the consent of the resident. The right to reasonable access to a private telephone. Again, during COVID, this is implicated. The right to share a room with your spouse with consent. The facility must allow resident and family groups in the nursing home, and the right to have your dignity maintained. And self-determination is a big concept in the new revised OBRA regulations. Underneath that are many different rights related to self-determination, including the right to visitation. There are some other sections of the OBRA regulations that do give us guidance on quote unquote rights. The facility cannot require a third-party guarantee of payment. They cannot state that someone has to sign to guarantee the nursing home bill before they will admit the patient. The resident also has the right, and the facility must provide immediate access to others that they wish to visit. Again, a difficult one at this time. Free from chemical restraints, that is a right within the OBRA regulations for nursing homes. A couple of these are repeated rights. Some of the care standards are also sometimes thought of as standard of care. The resident who enters the facility without a pressure sore shall not develop one unless it's clinically unavoidable. The facility must provide the resident with sufficient fluid intake to maintain proper hydration. Again, all of these are guiding nursing homes. I'm moving to Minnesota Healthcare Bill of Rights, which governs Minnesota nursing homes. Under the Healthcare Bill of Rights, you see the right to have a continuity of care, to refuse care, to be free from maltreatment, to have confidential records, have responsive service, communicate privately with others, associate freely, meaning visitation, not be arbitrarily discharged, and the right to request and consent to a restraint. I will talk about that a little bit more later. That is often coming up in client questions to myself. There are a whole host of rules that also enumerate the rights under the Healthcare Bill of Rights, such as to a telephone, visitors, and to pet animals. The right to healthcare records is also in that Minnesota Healthcare Records Act. The rules, again, with nursing homes under Minnesota law, we go to both the statute and the rules. In the home care context, all we have is the statute. We do not have the rules that provide additional detail. One thing I wanted to touch on, because again, people ask, do they have the right to discharge me? I can't pay the bill. We're waiting for medical assistance to answer as to whether I will qualify. They can't kick me out, can they, when the bill is left unpaid? Well, they actually can. The 6 grounds for discharge from a nursing home is that the resident has needs that cannot be met in the facility. The resident no longer needs the services. The resident endangers the safety of others, endangers the health of others, fails to make or ensure payment for care, and the facility ceases to operate. So that failing to make or ensure payment for care, ensure such as apply for medical assistance, that's an important one. And it is a grounds for discharge. The procedure under the OBRA regulations is that the facility must provide notice and the grounds. They must include the right to appeal. You will see under Minnesota law here that the resident also must be notified in the grounds of discharge. But we have an appeal process in nursing homes where within 14 days of receipt, actually, it's within 30 days of the receipt of the discharge notice, a hearing shall take place with the administrative law judge within 14 days of the receipt for the hearing request. So an administrative law judge can hear the appeal. They can come to the nursing home room where the resident resides, and they can hear the appeal on a lack of payment, on whether the facility can meet the needs, and they will make a decision. And the decision is appealable to other courts. Oftentimes with the care needs, it doesn't go further. And in fact, in Minnesota, we have roughly 10 to 15 of these only in the given year, because either the resident or the facility has figured something out given the immediacy of care needs. So under Minnesota law, this is detailing the process under Minnesota law and some key laws that would inform that process, what I've already described. One thing to note here with the admissions process in nursing homes is that we do have a statute, 144.6501, that governs admission requirements in terms of who signs the admissions agreement. And it should be noted that no one, when you're entering a nursing home, no one needs to sign the nursing home agreement. The nursing home asks the resident to sign. If they can't sign, the doctor documents why they can't sign. Perhaps they can't understand. But they cannot require someone else to sign the nursing home admissions agreement in the nursing home context. They cannot deny admission because someone doesn't sign. Now that is different in the contractual agreements governing landlord-tenant and home care services in the assisted living environment. All right, I'm going to skip over this one. You can, this is what I just talked about the signer. These are the laws that are on point to who needs to sign and who doesn't need to sign, essentially. I'm going back to that right to a restraint. This often comes up. This is in the Minnesota Healthcare Bill of Rights as to nursing home residents. Competent nursing home residents, family members of residents who are not competent, and legally appointed conservators and agents. So residents and their agents have the right to request and consent to the use of a physical restraint in order to treat the medical symptoms of the resident. I often state to the resident and family, did you ask for the quarter railing on the bed, which is a typical one, because they believe that will assist in not rolling out of bed, for instance. And there's concave mattresses and some other non-restraint alternatives, which are often explored. But the resident has a right to ask for a restraint. There is a process, and there's more to this particular law on the use of restraints, but I wanted to highlight that because sometimes we have significant fear of falling, a significant fall risk that we're hearing that restraint is just told, the members are told they simply won't do it. The facility won't do it. So I wanted to highlight this one. We're moving to the Home Care Bill of Rights, which governs assisted living. The Home Care Bill of Rights talked about the right to receive services from a current and up-to-date plan, to refuse treatment, to choose your provider freely. Again, you don't have to use the one the facility offers. To have access to your records, to be served by trained and competent staff, to receive reasons for your termination of services, to make a grievance, and to assert your rights. We'll talk about that in enforceability. Overview of home care rights governing assisted living. There's services. There must provide a written notice of a termination of a service plan, and this is an important topic during COVID. We're trying to increase protections in the law to prevent terminations of service plans because of the detrimental effect during COVID. It is a 10-day written notice normally, except that under the assisted living title protection, it increases to 30 days. And under 504B, it's 30 days. So I have had frequent calls of 5-day notice. That's against the law. That's against the provisions of the law. 10 days for home care only, 30 days for assisted living. There are some exceptions for immediate termination as well. All right, assisted living discharge, we have a process here. Now, we do not have the appeal right currently for assisted living termination of services. Facilities typically do not evict. We would have some housing court options if they did retake ownership of the particular room, for instance, but the termination of services does not come with an appeal right currently in Minnesota law. I have listed some home care laws that operate as standards of care, or we may consider them a right to be served by a trained worker. The right to a basic service review or comprehensive services assessment by an RN, the timing of all of those things. That's what this home care law is summarizing. The right to be free from restraints in a housing with services environment. Particularly, we've had some past cases where we have had egregious restraints going on in housing with services, notably in our mental health communities. And so we have under our 144D, which is the housing with services law, the right to be free from restraints. And then we have in the Healthcare Bill of Rights, the right to a restraint. So we have to see all these things work together. By the way, I would ask more often as residents and clients for policies and procedures. That is, I think, an important right that residents and those receiving services have, to ask for those policies and procedures to better understand whether they're being followed. All right, enforcement of rights. Well, it's a little bit of bad news, but don't take it as all bad, because I want people to engage where they can on this. Generally, rights are largely unenforceable. In the nursing home context, the overregulations, we've had case law that states that they do not create what we call a private right of action, meaning you have a right to be free from maltreatment. Does that alone create an action where I would say in my claim, you violated the right to be free from maltreatment with damages because it resulted in injury or death? I cannot make that claim. It comes under medical malpractice, under a civil claim. It does not come from a statutory claim. That's what private right of action means. Just because it's in statute, you didn't do it, that's an automatic claim related to violation of that right. Minnesota does not have a private right of action for their healthcare bill of rights, home care bill of rights, any bill of rights. But here's what I want you to understand. In the healthcare bill of rights and in the home care bill of rights, there are provisions for the resident and their interested person or agent to enforce the rights. This has been, I recently had a case, I was not seeking damages to enforce the healthcare bill of rights. I was simply seeking an order from the court to enforce them. Stop doing what you're not supposed to do, start doing what you're supposed to do. And the court did allow that. We survived what's called summary judgment. We dealt with the case on different grounds because there was multiple claims. But the point being, I interpret both the home care bill of rights and the health care bill of rights to have standing to enforce them. Now, the cost to go to court to do that is prohibitive. Do you find an attorney to do that? Probably not. Pro se on your own, do you try to do that? Maybe. It's very limited, but I want you to understand that it's there to enforce the rights. In home care language, it's called the client or representative may assert the rights. So in summary, some courts recognize standing to enforce the right, but do not recognize a private right of action. That's what some of our legislation has been about. Allowing even attorney costs to bring the claim so that we have some incentive for people to really seek civil enforcement of their rights. In the assisted living context, we have less recognition of standing. It doesn't have quite the language that the Healthcare Bill of Rights does, but it is still language in there. Short of the private right of action or trying to enforce the rights to the court, we talk about informal resolution, trying to work through grievances and complaints. Those are some of the things we're governed by right now. This is a graph just based on my observation of things of rights that may have little enforceability, some enforceability, and more enforceability. There are some rights, such as the right to visitation, to privacy, to refuse treatment, that they might not result in harm. There's less enforceability, even under that asserting your rights kind of concept. Obviously, all of these can go through the ombudsman, and I encourage you to do so to try to try to assert your rights or the residents' rights, and also through MARC reports to the Minnesota Department of Health. But what we're seeing from a civil law perspective is that there's little enforceability options for the resident to enforce those rights. The admit and discharge procedure has some around it. The grounds for discharge are limited in the nursing home context, that is. The admissions agreement has some parameters around who needs to sign, who must sign, those kinds of things. So we have some, they're not in the Bill of Rights, but they're in other laws that talk about the process that's supposed to go on for these admit and discharge processes. Now, we might have a medical malpractice, injury, or death claim if we've got a changing condition, if we've got the fall with the fractured hip, if we have pressure sores, if we have sepsis. In the restraint issue, we might have some harm if they were restrained and had harm, or if they weren't restrained and had harm. So that's kind of a concept that I think about, where some of our rights are more enforceable than other, but I'm not talking just about the bills of rights. Okay. COVID-19. I just applaud all of you who are working your way through this. We just heard of infections at a facility. It's very difficult, very difficult. I've just highlighted some of the rights that are implicated that we just talked about. So in the nursing home context, for instance, person-centered care, the patients and residents have the right to appropriate medical and personal care based on their individual needs. Well, if the individual needs range of motion exercises, if they need to be able to walk down the hallway, have mobility so they can maintain their level of muscle tone, to assist with a pivot transfer rather than the need for a two-person transfer, that is a big deal. When you get to a Hoyer Lifton two-person transfer, you are limited in your care options. And what we're seeing, which we were concerned about, is the social isolation not only affected the mental health, but the physical health, where residents were not able to get that basic exercise and range of motion. So this isn't a right that's implicated right now. The participation in the planning and the treatment. You're not able to go in for care conferences as family caregivers. You have the right, the resident has the right to discuss treatment and alternatives with caregivers, to request care conferences, and the right to include a family member in that. Now, I know we're doing that a lot, telehealth and via Zoom, which is good, but it does implicate that planning process. Continuity of care, cared for with reasonable regularity and continuity of staff assignment. We have short staffing in our facilities right now. This is the Healthcare Bill of Rights governing nursing homes. But with this short staffing comes irregularity. We are seeing many more temporary workers who are coming in who don't have knowledge of the resident, and we're seeing injuries because of an inability to read or understand the current orders or treatment plan. And so that is a concern, the regularity and continuity of staff. It is for the providers as well. The right to be free from maltreatment. We're concerned about neglect and abuse going on in the facilities without others being able to see what's going on. The right to a prompt response. The residents have a right to a prompt and reasonable response to their questions and requests. There's not enough time right now to respond to some of those questions and requests by staff. These are all rights that that residents have that during COVID are limited. Make a grievance, you can still do that. Communication privacy is another big one. The patients and residents may associate and communicate privately with persons of their choice. That is particularly with those with advanced dementia. They're not able to do that often. If they can't figure out how to do the iPad, things of that nature, and it requires staff time. Many providers are really working hard to get that communication done, but others don't have the ability. Visitors and association, this is probably the biggest one that we see, is a right that really is having a significant negative impact. The rights of the resident to meet with and receive visitors, to join with other individuals within and outside the facility, to visitation by an individual appointed as the agent, to make, to appoint an individual designated by the patient. So it talks about being able to be inside, be outside, associate with different groups in the community, and visit who you want. Particularly under the OBRA regulations, it's even more clear. The resident has the right to receive visitors of his choosing at the time of his or her choosing, subject to the resident's right to deny visitation when applicable. They could say they don't want to visit, but in a manner that does not impose on the rights of another resident. And that's where we see some of that balancing. The facility must provide immediate access to a resident by immediate family or another relatives of the resident, subject only to the resident's right to deny. So these are really important rights, and moving about freely, the right to interact with members of the community, access to providers and professionals. We talked about medical records, telephone and video. The federal regulations to nursing homes do include that video communication, which is directly on point to COVID, a right to that video communication. The notification of changes in condition, the facility, this is another concern we're hearing greatly about communication, lack of communication. So the facility is to notify the representative of changes in condition. The privacy we've talked about. The right to a safe and clean environment. We are hearing of significant, how do you even describe some of the circumstances and living environments we've heard about that have not had laundry done or that have not had basic cleaning done. We talked about grievances. You do have the right to be with your spouse as well, and this is challenged during COVID. The only limitation in law that I see, and I'm going to stop here in just a second, is the facility must have written policies and procedures regarding visitation, including those set forth that are talking about any clinically necessary restrictions. And that's really what we're in right now. This is under the federal OBRA regulations. Assisted living, I'm going to work through. It's similar rights during this COVID time, we have 53%. This just came out in the recent visitation guidelines that came out yesterday. 53% of our nursing facilities have had COVID. We have an average of 22 cases per facility that has had COVID. That's about 31% of those residents are dying. In the assisted living, 25% of assisted living facilities have COVID cases. There are an average of 6 cases per facility with COVID, and 31%, the same, of residents are dying. Minnesota Department of Health has many guidelines. I've linked them here. The key ones we're talking about right now are essential caregiver and the new ones that came out just yesterday. One thing to understand, I'm going to just pass through the essential caregiver, unfortunately. With the new guidelines, though, it's not a reopening plan. Testing is integral. It does not cover independent living largely, but they actually do state that those independent living settings in a campus model would have the same restrictions except for screening and testing. So that's important to note. The basic premise of the new guidance is that level 1 is for facilities who have not had a facility onset transmission or one staff member working while infected in the last 28 days. So essentially, the current toolkits are level 1. The current guidance is level 1. If you can move to level 2, you haven't had these cases within 28 days, there is an opening of some of the visitation guidance and other guidance, dining and activities. But all of it kind of goes back to what the instructions have already been with the toolkit, etc., plus some additional guidance for level 2. That's a really simplified version. Executive orders, there's a lot of them. I'll let you look at that as you're at your leisure. I am going to get to practical tips. Remember, all procedures are altered during COVID. We're all dealing with it. Unfortunately, the long-term care communities have been hit hard. Also remember, however, that the person receiving the services retains rights. Know them, assert them. Contact the ombudsman. As possible, focus on the items of greatest importance and give on others. Ask for their policies and procedures. If possible, ship them a camera to the resident that they might be able to put in their room with the proper notice and consent under 144.6502. Tell the facility the communication preferences. We're hearing that they put it in my chart, but they didn't call anybody, and some of us aren't going online to find those updates. Ensure that the resident has designated multiple people to receive care updates if possible. That might flow into multiple essential caregivers, for instance. Recognize that this is guidance. It's not in law or rules. The interpretation is up to the provider. Keep in contact with the primary care physician and any provider that's unaffiliated with the facility so they can continue to be aware and give input. Got some wild ideas there, but according to facility policy, consider taking that person off-site. We're hearing sometimes that if they go off-site, they're going to have to come back to a 14-day quarantine period. But sometimes there's a really great necessary need to interact. So some family members are opting for that quarantine so that they can have some of the visitation that they believe is necessary. If necessary and safely possible, you might consider a new living situation. We're hearing so much from the independent living environment. It might be that they need to get into a different apartment. I know that's not an easy answer, but they simply are more restricted in those campus models. Participate in advocacy, broad advocacy. What you do to help your loved one helps others too. And that's where Elder Voice comes in. So I thank you very much, and I'm open to any questions.
Okay, sorry about that, get my mute up. Thanks a lot, Suzy. As we wait for any questions come in, can you comment on the Victims Fund? That was something that did get established in the law that we all worked on last year, and how that works and how it can be applied.
Sure, I think you're talking about the Maltreatment Compensation Fund.
We call it, yeah, you're right.
Okay.
That's
Okay.
the technical term, yeah.
No, that's fine. If the Minnesota Department of Health conducted an investigation, it might even be DHS too, but if there is a substantiated maltreatment after an investigation of a certain level of harm, there is available to those residents or family members a compensation of up to $5,000 for the substantiated maltreatment. There is a letter that is sent out to the family where they can opt to receive that $5,000. It is important to note that is in lieu of a civil claim, meaning if they accept the $5,000, they cannot bring a civil claim. So they're waiving their right to a claim of medical malpractice, wrongful death, personal injury, if they do accept the $5,000. So it is seen as a stopgap measure it actually sunsets when assisted living licensure comes in. It was thought to be a temporary fix, if you will, to the lack of termination appeals that are currently non-existent for the assisted living environment, and some other protections that don't come on board until licensure. But it's critical that it's actually pretty limited in who receives that communication, but it's also important to understand that you're foregoing a civil claim. You're giving up a right when you accept it.
Suzy, we've got a question. What can be done when the county coroner signs the death certificate for injuries in a memory care?
So I'm not sure if the question is whether or not someone else besides the county coroner should be signing that death certificate. And if it's that question, I would, the county coroner does not get involved actually very often. I typically find that to be a positive thing sometimes, because they're looking at it from an injury standpoint. They're the ones that might say manner of death, accident versus natural, for instance. If it's trying to amend the cause of death, I have done that successfully by asking whoever signed the death certificate to look at other records so that they could include an underlying condition. For instance, if they had a fall 6 weeks ago and then they died of congestive heart failure, I've asked them to look at the fall as an underlying cause of death and add that, because there was decline that started from the fall. The coroner typically gets involved when there's an accident and not a natural death, but maybe in a different area. It's different. In any case, the attending physician is the one who I most often see signing the death certificate.
A question that I have, Suzy, is we're seeing a lot of we're hearing at Elder Voice anyway a lot of violation of these basic rights. Are you also seeing an increase of that in your opinion? Is that being driven by COVID, or are there, just tell me what you think the scope of this is?
Yeah, I'm seeing, I obviously am seeing a lot more violation of rights. And again, in this community of consumer advocacy, you have people that believe it's unconstitutional to do what is being done right now in long-term care facilities with restrictions on visitation. And this is why, because these are key rights that they have available for their quality of life and care. And that's why they're in there in the Bills of Rights. So you come from that perspective, and then you come from the perspective of the higher risk population of the spread of COVID within the long-term care facility, and restricting rights in order to get at that risk factor. And then many people are in between. So I am seeing more a violation of rights. There literally is not a resident right now whose rights are not being violated, in my opinion, because just by nature of the fact that their visitation is restricted alone, and that they're not able to communicate freely with who they choose. That's happening in every facility, essentially. So it's what you do about it that's the difficulty. And I think it's during this time that people are tolerating those violations. In fact, one of the executive orders gives the Commissioner of Health broad latitude and authorization to alter some of the rules and regulations because of COVID. So I think we have to we have to do some balancing, but I think we're, in my opinion, forgetting what those rights are to a greater extent, because we as quote unquote able-bodied people have raised that flag in our stay-at-home order context and in our freedom of association and visitation, those are some of the arguments that kind of came up to say, you can't really ask us to do that. We have some freedoms. Well, there's similar freedoms and actually even more freedoms in the healthcare environment because of the vulnerability and the desire to protect a person in that environment. So it's a difficult balance.
There we are. Well, we've used our 1 hour. I thank you, Suzy, very much. And we're getting great reviews on you, by the way. So, and what we're all pointing to, and what we all know, COVID's really exposing the systemic failures that we see in a lot of our long-term care facilities. And I just want to assure everybody who's attending that Elder Voice Family Advocates is going to remain vigilant, active, and aggressively working to protect our residents and our families. With that, thank you very much for attending, and remember that both the presentation, both the video and the voice, will be on the website, and I know Suzy's open to questions. Please feel free to contact her. Thank you very much.